Welcome to Drishti Judiciary. This MCQ series for the Supreme Court Clerk Exam will sharpen your accuracy, strengthen concepts, and help you master the exam pattern. Let's begin. Let's start with previous day's practice question. The question was, under the Indian Contract Act 1872, which of the following statements is correct regarding consideration? A. Consideration is not necessary in contracts made out of love and affection. B. A contract without consideration is always void. C. Consideration must be lawful, but it need not be adequate. D. Past consideration can be a valid consideration for a contract. The correct answer is option C. Section 25 of the Indian Contract Act states that consideration must be lawful. However, the law does not require the consideration to be adequate, that is, the value need not be equal to the promise made in the contract. Hence, C is the correct option. Let's begin today's session. The first question is, in Anup Baranwal versus Union of India, the Supreme Court provided directions on the appointment of election commissioners. Which of the following did the court direct? A. The election commissioners shall be appointed by the President on aid and advice of the Council of Ministers. The President does not have any discretion in accepting or rejecting the advice of the Council of Ministers. B. The election commissioners shall be appointed not by the President, but by a 3-member committee comprising of the Prime Minister, Leader of Opposition, and the Chief Justice of India. C. The election commissioners shall be appointed by the President on the recommendation of a 3-member committee comprising of the Prime Minister, Leader of Opposition, and the Chief Justice of India. D. That the current practice of appointing election commissioners is valid and requires no change. The correct answer is option C. In Anup Baranwal versus Union of India case, the Supreme Court provided directions regarding the appointment of election commissioners. The court emphasized the need for a more transparent and independent process to ensure the impartiality and fairness of the election commission. Hence, C is the correct option. Next, please identify the incorrect statement in the context of the examination of a witness. A. The order is the examination in chief followed by cross-examination followed by re-examination. B. Purpose of examination in chief is to take the testimony for which they are called by the party. Cross-examination is to test the veracity of the witness, and re-examination is to remove inconsistency that may have arisen during examination in chief and cross-examination. C. No leading question can be asked in examination in chief without the permission of the court. Leading questions can be asked in a cross-examination and re-examination. D. No new matter should be introduced in re-examination without the permission of the court. The correct answer is option C. Leading questions are generally allowed in cross-examination, but the statement that leading questions can be asked in both cross-examination and re-examination is incorrect. Re-examination is meant to clarify things, not introduce new matters or lead the witness. Leading questions are not typically allowed in re-examination except under specific circumstances or with the court's permission. Hence, C is the correct option. Next, which of the following is murder? A. Astha and Simon were sitting in a tavern playing cards with a group. Suddenly, due to a misunderstanding, a fight broke out in the group, and in the heat of the moment, Astha hit Simon and Simon collapsed on the spot. Astha immediately got first aid for Simon, but it was too late and Simon died. B. Yasmin and Zahir are neighbors. One evening, Zahir makes a derogatory remark about Yasmin's community. Enraged under this provocation, Yasmin kills Zahir's child. C. Police Inspector Bholo spots Dabru, who he knows is wanted by the police on several counts of dacoity. Bholo tries to apprehend Dabru, but Dabru does not heed him and tries to run. Bholo grabs Dabru in the chase and they get into a tussle causing Dabru's death. D. Both A and B. The correct answer is option B. Here Yasmin's act of killing Zahir's child in response to verbal provocation is an excessive and disproportionate act that amounts to murder. Hence, B is the correct option. Next, Mr. A wrote to Mr. B, "I'm willing to sell you 100 grams of gold after 5 months at the then prevailing market price, but in no case at less than ₹600 per gram." Assuming that this statement is the first in the line of correspondence between Mr. A and Mr. B, what is the nature of this statement? Invitation to offer, an agreement to void for uncertainty, or an agreement of sale of goods? The correct answer is option A. The statement made by Mr. A to Mr. B, "I'm willing to sell you 100 grams of gold after 5 months at the then prevailing market price, but in no case at less than rupees 600 per gram," is not an offer but an invitation to offer. This is when a person expresses their willingness to negotiate or deal under certain terms, but they are not making an offer that can be accepted to form a contract. It invites others to make an offer. Hence, A is the correct option. Next, in which judgment did the Supreme Court craft the remedy of curative petitions? CBI versus Keshav Mahindra, Rupa Ashok Hurra versus Ashok Hurra, A.I. Antulay versus R.S. Nayak, or Khode Distilleries versus Registrar General Supreme Court of India? The correct answer is option B. The remedy of curative petition was crafted by the Supreme Court of India in the case of Rupa Ashok Hurra versus Ashok Hurra 2002. This judgment introduced the curative petition as a remedy to correct a decision made by the Supreme Court that may have been pronounced due to some error or oversight. Hence, B is the correct option. Next, requiring an accused to produce a signed document with a view to comparing her signature does not violate the right against self-incrimination recognized by Article 20, Sub-Article 3. In which case did 11 judges of the Supreme Court come to this conclusion? Kalavati versus State of Himachal Pradesh, Nandini Satpathy versus P.L. Dani, State of Bombay versus Kathi Kalu Ogad, or State of Gujarat versus Shyam Lal Mohan Lal Choksi? The correct answer is option C. In this landmark decision, the Supreme Court concluded that requiring an accused to provide a specimen signature for comparison did not violate the right against self-incrimination. The court held that Article 20, Sub-Article 3, which protects individuals from being compelled to testify against themselves, does not apply to the production of material. Hence, C is the correct option. Next, which one of the following amendments was not brought in by the 44th Amendment? A. Replacing the phrase internal disturbance with armed rebellion as requirement for declaring emergency. B. Enforcement of Articles 20 and 21 could not be suspended during an emergency. C. The recommendation of imposing emergency from the Council of Ministers had necessarily be in writing. D. The word socialist was added to the preamble of the Constitution of India. The correct answer is option D. The 44th Amendment to the Indian Constitution was passed in 1978. Primarily aimed at restoring and strengthening democratic values and limiting the scope of emergency powers that had been used during the emergency period under Indira Gandhi's government. The addition of the word socialist to the preamble was made by the 42nd Amendment, not the 44th Amendment. Hence, D is the correct option. Next, nothing is an offense if committed by a child of less than 5 years of age, 7 years of age, 5 years of age, but if over 5 years of age till 12 years of age, then the judge is to evaluate the mental capacity of the child. D. None of these. The correct answer is option B. Under Section 82 of the Indian Penal Code, it is stated that nothing is an offense if committed by a child under the age of 7 years. This means that a child below the age of 7 cannot be held criminally responsible for any offense committed by them, as they are considered incapable of committing a crime due to lack of understanding. Hence, B is the correct option. Next, which of the following statements correctly describes the concept of mens rea? A. Mens rea need to be present at the stage of planning, but not at the stage of commission of the offense. B. Mens rea should be excluded unless the statute specifically requires it to be proved. C. Absolute prohibition is not required to negate mens rea. D. If the statute is silent about mens rea, as a general rule, it should be read into the statute. The correct answer is option D. Mens rea refers to the mental state or intent of a person at the time they commit a crime. It's often referred to as the guilty mind, and it is a crucial element in determining criminal liability in most legal systems. The presence of mens rea typically indicates that the individual had the intention or knowledge of committing a criminal act. If the statute is silent about mens rea as a general rule, it should be read into the statute. This is the correct statement. In criminal law, if a statute does not explicitly mention the requirement of mens rea, it is typically implied. This principle helps ensure fairness in criminal justice, as an individual should generally not be held criminally liable without the requisite guilty mind. Hence, D is the correct option. The last question is, which of the following are actionable in both civil and criminal law? Defamation, assault, trespass, or all these? The correct answer is option D. All the mentioned actions can be actionable in both civil and criminal law, although the nature of the legal proceedings and the remedies available may differ. Hence, the correct option is D. Now it's time for the practice question. The question is, under the BNS, when multiple persons are involved in the commission of a crime, what distinguishes the concepts of common intention and common object? A. Common intention involves a premeditated plan, while common object is formed during the commission of the crime. B. Common object is related to offences committed by a group, whereas common intention requires the presence of a shared pre-arranged plan. C. Common object involves a collective mental state, whereas common intention relates to individual motives. D. Common intention applies only to physical acts, while common object applies to verbal agreements. Send the answer to this question in the comment section. That's all for today's MCQ session. If you found this helpful, don't forget to like, share and subscribe to the Drishti Judiciary YouTube channel. See you in the next session. Keep preparing.